the endless litany of things that I find interesting when I'm listening to these cases, and particularly trials. I've actually often wondered this, having recently sat on a jury on a murder case myself just a couple years ago. And that is, they read the preliminary jury instructions to the jury before the trial. And then at the end, once all the argument, what they call a charging conference, once they've ironed out everything that's going to be on the final jury instructions in the verdict form, one thing has always stood out as confusing to me, and I often wonder if jurors themselves would be confused when they hear that they should not form any opinions on the case until they've heard all of the testimony and reviewed all of the evidence, and they go back to the jury deliberation room. But one of the other parts of those instructions is that, for instance, one of them specifically I think of is that they're able to make assessments of a witness's credibility based on how they testify or the content of what they testify on the stand. And I find those two instructions to just not be perfectly clear. I think and I've never asked an attorney or a judge this, perhaps I should, is I think that the instruction should be worded more carefully to say you should not formulate any final opinions, because you're always making assessments of the evidence as you go along. It's normal, it's natural, and I presume is okay, but you can't come to a conclusion until you've heard all of the evidence and listened to all the witness testimony. So that's, again, one of the endless things I find interesting about the work we do.